SwayamPrabha. Digital India. Educated India.
Welcome viewers, this is Dr. Ashwini Siwal from Faculty of Law, University of Delhi. I am with you with another interesting lecture in the series called Law, Science and Technology. This is lecture number 11 on topic Augmented Reality, and in this topic we will understand the definitional contours of augmented reality and the legal issues surrounding augmented reality. My dear viewers, this lecture series has been a 20 lecture series, has been a 20 hours lecture series basically, or is a 20 hours lecture series, wherein we are discussing very fascinating and interesting exponential technologies, or lot of new technological developments and their legal issues. So, in this lecture I am going to talk about augmented reality. So, let us first of all understand what are the different types of digital realities. There are many digital realities which are basically digital revolutions, or you may say these are new technological developments in the field of technology. First and foremost is augmented reality. My dear viewers, this reality basically is designed to add digital elements over real world views, and limited interaction lies here. On the contrary, there are other digital realities where sometimes you get the immersive experience, sometimes it is not just restricted to adding few digital elements, rather you fully immerse into those technologies. Like virtual reality is another immersive experience which isolates you together from the real world. Unlike AR, augmented reality is the technology where you are not isolated from the real world, but some digital objects are put over real world views, and you see certain digital elements in the real world view along with the real world. You do not isolate with the real world, but on the contrary, in the case of virtual reality, you immerse fully, and you see a different experience, or you usually feel or perceive a different experience. Here in the case of VR, you use headset devices, headphones designed for such activities. Then there is another digital reality that is called mixed reality, which is a combination of both AR and VR, where you isolate from the real world and you see certain digital objects being put also, and you can interact with the real world, means businesses can design elements anchored within a real environment. So, here in the mixed reality, you remain isolated from the real world, you see some digital objects and may see some digital objects put on or put over the real world. Then extended reality is another kind of a digital reality which covers all types of technologies that enhance our senses, including the three previous types mentioned. This brings more features in the existing digital realities like AR, VR, and then mixed reality, that is called MR. Then lastly, we have immersive technology. This immersive is called the immersive technology, which creates an immersive experience for users. It is a reality technology that either enhances or replaces a real life environment within a stimulated or virtual one. Immersive reality can be either virtual reality, augmented reality, mixed reality, or extended reality. So, well, my dear viewers, this last reality is a reality technology which enhances or replaces a real life environment, and it is based on the previous whole or sometimes one of those but it gives you immersive experience vis-a-vis to the one simple technology or reality, that is called AR or VR. Now, coming to the definition of AR, or understanding it in a more holistic sense, it refers to a technology that overlays digital information such as images, videos, 3D models onto the real world. It may put some images, it may put an image of a Pokemon anywhere in the real world, but you can see it on a digital device and you may try to trace it on a digital device. It may put some videos in the real world, or it may put some 3D models onto the real world. Unlike VR, which immerses users in a completely virtual environment, AR enhances the real world by superimposing computer generated content onto it, typically through the use of devices such as smartphones, tablets, smart glasses or AR headsets. Here the person does not isolate or remain disconnected with the real world. He is actually into the real world, but he also sees some digital objects like 3D models or videos or some images onto the real world. Then when it comes to AR technology, it integrates digital information with the user's environment in real time, allowing users to interact with both the physical and virtual worlds simultaneously. This can be achieved through various methods such as through the camera and display of a mobile device, or through specialized AR glasses that project digital content directly onto the user's field of view. So, my dear viewers, we at least at this juncture we have understood what does this technology do and how it is perceived, but here our job is not to understand more nitty-gritties about the technology as such, but rather the legalities of it, or the laws and the legal issues or the legal control mechanisms surrounding this technology. But before understanding the legal issues, it is also necessary for you to understand what are the challenges or key issues that it may pose, specifically how it may be hazardous, or it may be detrimental to the mankind or to the individual, because this technology is sometimes used in education or for educative purposes, for entertainment purposes, etc. Why and where does the question of posing a hazard or risk or some issues arise which will attract the legal control mechanism or the legal issues or legal provisions. So, this technology which blends digital content with the real world, it is meant to enhance users perception, and this concept of AR basically revolves around the idea of enhancing the real world with computer generated sensory inputs such as sound, video, graphics, GPS data. This is typically achieved through the use of devices like smartphones, etc., as has been explained earlier also. Now, the key components of this reality are as follows. It is real time interaction, and from these key components only we will understand what are the kinds of issues that it may perhaps pose, which will invite or attract the legal control mechanism or the laws to address or to regulate this. Well, it is a real time interaction. AR systems process and integrate real world sensory data with digital information in real time, like a GPS tool which gives you a real time data or the information, allowing users to interact with virtual objects and content as if they were part of their physical environment. So, this real time interaction with the real world or with the world, and then having a sensory perception out of it is one of the key components of this particular reality or a digital reality called augmented reality. And this reality use sensors like cameras, GPS, accelerometers, depth sensors to understand the user's position and orientation in physical space, enabling the precise placement of virtual objects within the real world environment. And this spatial awareness is also a key component of this augmented reality, because it uses such sensors and it understands the user's position in physical space, which enables precise placement of virtual objects. When it does so, it may even locate the physical location of a individual using it and may share it with somebody else. So, here we begin discussing or brainstorming on the kind of issues which it may pose and which may attract some legal provisions, or which may require some legal mechanism to control such issues. So, sharing that person's location on a say augmented reality video game which you are playing may land him into a trouble, or that location shared of particular person may get shared with somebody who wants to do some crime. So is the case with while using such augmented reality experiences, especially the video games. You might play a video game in a very sensitive zone, where the information about that zone is susceptible to crime or susceptible to some kind of a terrorist activity, or it may lead to some law and order situation. So such issues or such components or such key characteristics of this technology are posing a lot of risks. Then the digital content in augmented reality is typically displayed overlaid onto the user's view of real world, either through the screen of a device like a smartphone or through transparent displays in AR glasses or headsets. Then they have contextual relevance. These AR technologies or experiences, these experiences I mean of the AR are often contextually relevant, meaning that the digital content is tailored to the user's surrounding and activities, providing information, guidance and entertainment that is pertinent to the user's current situation. It has some such key features where the things can be customized for users experience, or customized according to the users experience, or tailored according to the users experience. So when AR inbuilt games or AR inbuilt entertainment products are used or are experienced, you find that they are customized according to your needs, and that customization may be problematic at times, because again I will say that it may lead to some issues which may attract the legal provisions. We will discuss those. Then it enhances the user's interaction through various input methods such as touch, voice commands, gestures or even eye movements, enabling immersive and intuitive experiences. So here if you are suppose communicating or corresponding with somebody online with the AR facility, with the augmented reality tool which allows you to touch or make the addressee to whom you are talking feel like as if you are touching him or her, or your voice command as if it is being given in the physical world to him. So such such things or such features may again be problematic, because there have happened an instance where a woman was virtually groped, and she complained that as if she was physically groped, or she felt as if she was physically groped, but no law which punishes such groping or such kind of act is in existence. So the lawmakers should accordingly change the laws or make the changes into the respective laws, so that such incidents may not occur of these technologies, which are very promising otherwise and which offer immense opportunities and usages. So far as some more aspects or types of AR are concerned, these ARs are marker based or markerless. When it comes to marker based augmented reality, it is triggered by physical photos or markers captured by smartphone cameras to place the digital component on top of it. The markerless is more complex and does not rely on markers, and instead allows users to decide where to display the content. So this technology is still considered safe, because here there are markers predetermined by the makers of this technology, or any entertainment device, or a video game, etc. But in the markerless AR, the user will decide where he will put that digital object, or on top of what he will put that digital object, and this may lead to certain problems, because he might put that digital object to a building or to a particular statue or somewhere else where it might look bad, or where it might look scandalous. So these markers are missing in the case of markerless AR. The devices use a recognition algorithm to look for pattern, color and similar features to determine what an object is. The devices will rely on GPS, accelerometers, cameras and compasses to superimpose an image within the real world surroundings. So AR cannot function without the collaboration of some other devices like GPS, accelerometer, camera, or smartphone is required to use these things. But the point is that these are markerless ARs or augmented reality tools where the issues may be more or may get more complex, unlike the previous category, that is marker based AR, like a QR code or a logo, where already it is predetermined that you will scan only the logo or a QR code. So, when it comes to common application of AR, it include gaming, education and training, retail and marketing. So, when it comes to gaming, in the gaming people enjoy putting the digital elements onto the real world, creating interactive experiences for them that blend virtual and physical environments. In the case of education, it can be used to enhance learning experiences by providing interactive visualizations and simulations that help users understand complex concepts in real world context, staying somewhere else. You are sitting in a far flung area, and you are facilitated to physically see the laboratory in IIT Kanpur, and you may experience things by touching them, by as such perceiving them as if you are yourself available there. It is also used for retail and marketing. It enables virtual try on experiences for clothing and accessories. We all see that these days we use such platforms, such websites, where we are facilitated or enabled to put the specs on our faces, and we may choose the spec which fits well on our face and which looks well on our face merely by visiting the website, and we are not supposed to go to the shop and accordingly buy, or go there and physically buy a product. So, you just have to do what? You just have to put that particular object digitally on your face or on your photograph clicked by you, which which gets stored there. So, when you click that photograph, it requires your photograph, which means the privacy of yours is compromised. So, is the case with some other technologies where you may do some retail or marketing, you may interact with the different organizations for product demonstrations, for location, etc., in virtual space without being physically present there. Then there are a couple of other things which it does. AR helps in mostly in the navigation apps, overlay direction cues, points of interest and other relevant information onto the user surrounding. It also sometimes used for maintenance and repair, because through it real time guidance and instructions can be given. It may be also used in healthcare, like it has application in medical training, surgical planning, patient education, etc. Then in architecture and design, it is also used to build designs at scale in real world environments, allowing stakeholders to better understand how structures will look and function in at their intended locations. So, overall AR enhances the user's perception of reality by seamlessly integrating digital content into their surroundings, opening up a wide range of possibilities for entertainment, education, commerce and productivity. Now, coming to legal issues, as I said that for us it is important to understand the legal issues pertaining to AR. We have most of you must have, or all of you must have understood by now how does it function and what does it do, and where all it is used. Its scope is there in the gaming, in the education, in the training, in the marketing industry, in the other industries as well, and it works by putting a digital object into a real world environment, and it gives you command or the control over putting that object into a real world environment, and you feel as if you are physically present there, or some digital product or digital content which you are putting there is physically present there. So, now coming to the legal issues or challenges across various domains of AR, here are some key areas which we need to ponder and which we need to discuss in great detail. The first and foremost is the privacy and data protection. Well, AR applications often collect and process sensitive data. Now, here I will pause and tell you that it is not possible for any AR application to function without having control or without having collected your or processing your sensitive data, such as your location, information and images of you and your surroundings. So, is not it problematic that any AR application which you are using is requiring you to share your personal information or your sensitive data, your location, your image, your other informations, your surroundings, etc. Here lies the possibility of commission of any kind of a crime, apart from the possibility of misuse of the sensitive data. So, ensuring compliance with the data protection laws is imperative here, but are our data protection laws adequate enough? Are they have the provisions or do they have the provisions to cater to these aspects? Well, so far as sensitive data is concerned, or your other information is concerned, the Digital Data Protection Act of 2023 grants you a protection, and it's in a general context, it grants you some protection or some rights. So, you may probably use the same rights for enforcing your information, or your right of keeping your information safe by invoking those laws, even in the case of AR applications, right. Then we have some more issues pertaining to, or some more legal issues pertaining to this technology into its various domains, that is intellectual property rights. AR content may incorporate copyrighted works, trademarks, or other intellectual property owned by third parties, and legal issues related to infringement of that trademark, patent, or copyright, or unauthorized use of that intellectual property can arise in the context of AR development and its deployment. In both the cases, in the development as well as in its deployment, there may arise the infringement issues, and because they incorporate copyrighted works, or at times trademark bearing goods or other intellectual property owned by third parties, but yet they are used by either the users or subscribers of those AR applications, or by the makers of the ARs or AR applications, right. Then we have some more issues about the liability in the in the case of AR experiences, because it overlays digital content on the physical world, and determining liability in case of accidents involving AR technology, such as distracted driving or pedestrian collisions, may involve complex legal questions regarding negligence, product liability, and duty of care. So, there are issues spanning across proprietorship of the intellectual property, to your privacy, to liability in the cases of accidents involving AR technology, such as distracted driving or pedestrian collisions. At times we come across people playing games, and they are tracing certain things on roads, those digital objects which are placed by those AR video games on those roads, and they in that moment of joy or entertainment get hit by the cars. So, it is whose liability? Is it the liability of the driver who hit him, because this man jumped in search of a digital object which is lying on a road in the game, or it is a fault of the AR application maker who has put that particular object onto a road for him to search and track, or is it a fault of the individual himself? So, here may probably arise the concept of contributory negligence, because the person who is the victim here, the deceased, or the person who got hurt in an accident, he has contributed to the negligence of whom? Was that driver negligent? I believe the driver was driving a car, but this man jumped in search of a digital object, but on the contrary, that digital object was not visible to the driver at all. So, who is liable in this case? This is a grey area, and this kind of situations are arising in real time. So, these involve complex legal questions and complex legal issues in fixing or fastening the liability, or a care of a particular duty of care of a particular AR maker, or product liability of a AR maker. Then it may cause or result into public nuisance and trespass. AR applications that encourage users to interact with virtual content in public spaces may raise concerns about public nuisance and trespass. Issues such as obstructing sidewalks, creating disturbances, or entering private property without permission could lead to legal disputes and regulatory challenges. At times it has been seen that people enter into the property of others, and which is an offence of trespass, in search of some digital object while playing a game, or they obstruct a sidewalk, which is again a traffic violation, or a crime in the context of traffic rules, and then create disturbances in the smooth or seamless plying of vehicles on road. Consumer protection is another issue which arises here. Using AR applications, consumers may encounter issues related to false advertising, deceptive marketing practices, or unfair terms and conditions. Well, ensuring transparency, accuracy and compliance with consumer protection laws are important for AR developers and businesses to maintain trust and avoid legal liability. The consumers may encounter issues related to false advertisement, deceptive marketing practices, or unfair terms and conditions while doing the retail or marketing through the AR applications, because digital objects may be put and false advertising may be done of a product which is actually not to be sold, or which is not actually offered for the sale. Deceptive marketing practices may also be opted, where some deceptive products may be shown to you. It also brings me to the intellectual property violation, like a violation of a trademarks. Regulatory compliance is another issue, depending on the nature of AR application and its intended use. Compliance with industry specific regulations such as healthcare, education, gaming may be required, and understanding and adhering to relevant regulatory statutory frameworks are essential to avoid legal penalties and ensure a responsible use of AR technology. But who understands it is a matter of issue, or is a matter of concern, because not everybody who uses the AR technology, everyone is carrying a portable computing device that is called a smartphone. The teenagers, the digitally semi-literate or digitally illiterate people are also carrying the these days lot of smartphones, or lot of advanced phones. So, over there lies a great concern of such issues to arise, especially when they happen to or they are prompted to download the AR applications, and where they start playing games, or doing marketing or retailing, etc. Such issues may arise. Then some other legal issues may arise, like cyber security and data breaches, ethical and societal implications. Well, so far as the cyber security and data breach is concerned, AR applications that rely on network connectivity and data transmission may be vulnerable to cyber security threats such as hacking, data breaches, and unauthorized access to sensitive information. So, we all know that most of these AR applications rely heavily on the network connectivity. So, while using these technologies, your data may get compromised and it may be hacked, or it may be breached. Implementing robust security measures and protocols are required to prevent such cyber attacks and such issues, but for that we need a very robust mechanism. Ethical and societal implications are also there. Beyond legal compliance, AR raises broader ethical and societal concerns, including issues related to cultural sensitivity, diversity representation, and the impact on social norms and behaviors. Addressing these ethical considerations and engaging stakeholders in discussion about responsible AR development and deployment are essential for fostering ethical innovation. Well, beyond legal regulations or legal compliance, AR raises question of ethical compliance or ethical issues as well, like cultural sensitivity or diversity representation and the impact on social norms and behaviors. It has been seen that usage of these technologies are to a very great extent leading to behavioral changes into the teenagers, into the adolescents, and even in the full grown adults, because they remain confined to these applications or such technologies, wherein they fully forget the real world and physical world, and consciously or subconsciously their behavior changes. And the another issue with the societal implication or ethical implication is about the cultural sensitivity and the diversity. So far as the cultural sensitivity is concerned, the person who is glued to these technologies, and suppose he is playing a particular game or entertainment he is enjoying or using. So whatever culture is shown there, that culture gets embedded into the mind or inculcated into his mind, and he lost the cultural sensitivity, or at times it leads to the insensitivity toward the culture or its diversity. So AR technologies, they continue to advance and become more integrated into everyday life. Addressing legal issues will be essential to promote these, and for that collaboration among policy makers, experts, industry stakeholders is required. Now coming to specific kind of legal issue, that is intellectual property issue, and in this segment we will see what other kinds of intellectual property issues may arise apart from what we discussed, and we will go into the details of each of the kinds of intellectual properties one by one, and see what are the nuances of those intellectual properties, or what are the application of those intellectual property legislation in the field of AR. Well, in AR technologies, IP rights come into two categories: real world IP rights in the virtual world and virtual IP rights in the real world. So viewers, you need to understand this first of all, that in the AR technology, intellectual property right may be available or applicable into two categories. One is real world IP rights in the virtual world. For example, somebody owns a real intellectual property right, but his or her work is being used or covered into a virtual world, right. Dusra category or the another category is virtual IP rights in the real world, where somebody's intellectual property right may get infringed, right, virtually, but that intellectual property right is available in the real world. So these are the two instances or two situations where within the domain of which we need to understand, or two different propositions within the domain of which we need to understand what kind of a implication will it accrue. So to make it more simpler for you, let me give you an example of the first category. McDonald's has a trademark on its brand in the real world, right. It is simple to understand that McDonald's is a trademark in the real world, but what if someone depicts a McDonald's burger or restaurant in a virtual world? Does trademark registration stretch to cover everything in a virtual world? Now this is the question, or you may say this is the matter of inquiry, or this is a matter for further investigation, that somebody in virtual world has depicted McDonald's trademark or the restaurant. So can the person who owns the trademark on McDonald's invoke trademark law and institute the infringement action against the infringer? So what the trademark law say in this context? The trademark law says that whosoever uses the trademark in the course of trade shall be held accountable and liable if he or she uses the identical, similar, deceptively similar or confusingly similar trademark, otherwise not. So what is the notable or noticeable thing here? That it has to be used in the course of a trade. But what if somebody has made a video game where the purpose of making the subscribers and through subscription the particular application, AR based application, is chargeable. So he is making money, or he is making monetary gains. So will it amount to use of that trademark in the course of trade or not? Is he trading on eatables? He is not trading on eatables, he is trading in the form of a video game, or you may say he is trading in a AR based video game, he is not trading on eatables, and he is showing the McDonald's trademark virtually, right, or a restaurant virtually in his application or in his game. So, these are some perplexing questions, which are yet to be answered, but the settled principles of law in this context, they give some insights, or they throw some light on these aspects. So, the present settled proposition of law or position of law on this point will perhaps not make him liable, because he has not used the trademark McDonald in the course of trade of eatables. Had he done it in the course of trade of eatables, he would have been made liable. But what if the same AR based application which shows McDonald or the restaurant, or gives a look and feel of the restaurant by making the person sitting in the restaurant, and his essential feature is delivery of the food products. A burger has been delivered to a person. Now, immersive experience is also offered to him to sit in the McDonald's restaurant live with the rest of the the guests or consumers who are sitting in the real time in the particular restaurant. So, such a service may make it more complicated. So, such issues are bound to arise in the cases of AR or use of the AR. When it comes to second category, that is virtual IP rights in the real world. For example, one person designs an app that geotags a building, and when he views the building through a smartphone, the app augments that view with information about the building such as height, number of tenants, who owns the rights, when you overlay information virtually onto a real physical object. So, this is virtual IP rights in the real world, or the example of virtual IP rights in the real world, because you have geotagged a building, and the feature of the app is that once the building is geotagged, it gives you the entire information, or about the building, or the height or number of tenants etc. staying in the building. So, who owns the right when you overlay information virtually onto a real physical object? Here who will get the intellectual property right, because lot of information has been overlaid virtually onto a real physical object. A building is there, but lot of information has been put there, that this building has 100 tenants, this building is of this height, this building has this many fire extinguishers, this building has so many stairs etc. etc. So, here there may arise the issue of again the intellectual property rights in the real world, which has been which are basically virtual IP rights in the real world. So, now coming to the solutions to it or insights on it. At the moment there are no effective laws on who owns such rights. Owners of landmark buildings might want to own those rights, but today they cannot control who presents information about their buildings in an augmented reality application. A building belongs to A person, but the B person here in this instance puts some information about that building in an augmented reality application, and the role of or the feature of the augmented reality application is to just geotag the different buildings. But once it has been geotagged, other information has been put by B person here. A building belongs to A. So, the A person whose building it is and who has got it constructed or who might have designed it might assert his intellectual property. He might say that it is his intellectual property, he has given the design etc. of the building, right. So, that might get infringed here. The other thing is an issue that is normally sorted out by a contract, but is still considered a grey area. Users can design and build things virtually. Say someone comes up with a really incredible and exciting design for a building or a city. Who owns the rights to that design? That is normally spelled out in the terms and conditions of the users, and are users are required to sign it, but that is not possible in the case of AR or augmented reality applications or experiences. The building, if there is a contract that exists which even extends to the use of the design of the building in the AR experiences, a real estate developer is there who has got some buildings constructed from some by getting it designed from some designers. The design right, unless there is a agreement contrary, the design right belongs to the designer, right. If he has not relinquished this right or given away this right through a contractual arrangement, it belongs to the author, and author is the designer. But what if the designer here has not given the permission of using the design of the building for virtual experiences to the people? So, in that case who will have the design right or that particular intellectual property right on that particular building? So, many questions may arise, but two important issues arise. Firstly, whether the protection under the current regime can accommodate IP created in virtual world, and secondly, whether the real world IP proprietors have any legal recourse for infringement of their IP in the virtual world. So, these are the issues which may going to arise or which have already arisen to a very great extent so far as the intellectual properties are concerned. Now, coming to copyright issues, there may arise many copyright issues as well, like issue of a trademark or a patent or a design. So, in the copyright or in the context of the copyright, the first and the foremost issue that is likely to arise is the issue of the ownership of AR technology. Here we will discuss predominantly AR. Under the Indian Copyright Act, copyright basically subsists on original literary, artistic, dramatic and musical works, or on a computer program too, because a computer program falls into the category of literary work. But source and object codes which constitute a computer program and which are essential to the creation of a AR or a VR software. So, such software will be protected by copyright laws once created. What does Indian copyright law say about it? So, Indian copyright law requires that in order for a work to qualify for protection, it would have to meet the skill and judgment standard laid down in Eastern Book Company case, and it would have to be minimally original, or you may say it will have to be have modicum amount of creativity and originality in it. So, in this case the court held that skill and judgment and substantive variation and not merely a trivial, that is mechanical variation, is required. So, if the AR VR software meets this threshold, it could qualify for copyright protection. So, any source code or object code which constitutes the computer program, which is essential for the creation of a AR software or a application, is copyrightable, but it is copyrightable only when it fulfills the requirement of copyrightability, which is skill and judgment as well as originality. If there is no originality in your work, it shall not get the protection. Then essentially the copyright or ownership are based on a combination of users input and artificial intelligence fed therein. Sometimes AR applications are made by user input on the one hand and AI or AI instructions on the other hand. So, in that case if it is a generative AI, who will own the copyright on that? Is it the person who caused the work to be done through that AI will get the copyright protection, or is it the AI as a tool which is not a juristic personality will gonna get the copyright protection? So, the Copyright Act under 2D6 provides that author in relation to any literary, dramatic, musical or artistic work which is computer generated is always the person who causes the work to be created. So, our law to a very great extent have the clarity on this aspect, that in the case when the AI has been used, and if that AI is basically fed or instructed or programmed or commanded by an individual who is claiming a right, then it is this person who has caused this AI to be created, and it is this person because of whom that AI has created the work. So, he will gonna get the right or ownership of that right. Few jurisdictions such as US have recognized that when aesthetic copyrightable works are created by using AR and VR technologies, it is the most proximate contributor to the direct expression of the work who will be given copyright. So, they have also recognized that it is the AR or the VR technologies which are the most proximate contributor to the direct expression. Whatever has been created with the help of AR application or a VR application, it is the AR or the VR application which is the most proximate contributor, but there is uncertainty in those jurisdictions as to who will be given the copyright, whether it is the AR or the VR, because they deem that it is the machine which is the most proximate contributor. It is the application which is the most proximate contributor. What we on the other hand, or on the contrary, see in our law under 2d6, that the person who has caused that work to be created, and it is the individual, it is the human who has caused this work to be created, who will be called the most proximate contributor to the creation of that expression. Now there arise few more complex or few more issues when it comes to derivative works. Well, a poster, a painting captured by AR software, as nothing actually changes on the physical poster or painting, is basically what problem, because the question of whether an infringement has occurred depends on how much of the original poster painting was reproduced within the computing world in order to create the effect. If AR application or a software uses a poster or a painting to create an environment which the user or which the end user of that particular software will experience, they sometimes use the posters, paintings, etc., and those posters and paintings at times are copyrighted subject matters, or are copyrightable or copyrighted actually by some people. So in this context, use of that poster painting will tantamount to reproduction or not, or you may say copying or not. It is something which is to be decided within the computing world in order to create the effect. Yes, it is an electronic reproduction, or you may say electronic communication. The cases are there where we may refer to certain cases to understand it. In one of the cases of EB Eastern Book Company versus DB Modak, the work that has been originated from the author and is more than a mere copy of the original work would be sufficient to generate copyright. The courts have only to evaluate whether derivative work is not the end product of skill, labor and capital, which is trivial or negligible but substantial. The courts need not go into evaluation of literary merit of derivative work or creativity aspect of the same. Hence, as long as the work created through the AR VR technology is not a mere copy of what was already available, and the user inputted enough skill, labor and capital in the creation of the work created in the AR world could qualify for IP protection. So this case law has thrown a light that in the cases of derivative works, trivial or negligible change is sufficient. There is no requirement of high labor, skill or capital investment. It is just trivial or negligible or some substantial change. So if somebody has put enough skill in changing the particular painting or a particular poster which is being made a part of a AR software, then in that case you may say so that the work created is a separate work altogether, because it is a derivative work and IP protection ke liye wo eligible ho jayega. Then copyright infringement also may take place in the cases of an AR or in the cases of augmented reality. The Supreme Court in the case of R.G. Anand has held that two works in question need to be examined from a holistic perspective and to judge the look and feel of both works in question of copyright infringement. So there are instances where the real world copyrighted works such as images, buildings and even statues are captured in the virtual worlds of AR, and the question which then arises is whether such use of copyrighted work would result in copyright infringement. The legal principle de minimis essentially refers to trivial legal violation. In the AR world, the same would need to be evaluated on a case to case basis depending upon the actual test of infringement. So whenever you are subject to the test of infringement in the case of intellectual property, and if you have copied some image or a building or a statue, or if you have captured an image, building or a statue in your virtual space of AR, then the question of copyright infringement shall be decided on the basis of settled propositions of law, where look and feel test shall be applied, and if the look and feel of the picture, poster, statue in the AR world is similar to some other work, then it amounts to copyright infringement, though the principle of de minimis shall also be taken into account, which means that if it is a if it is a minimal or a petty copying, then the person may not be made liable or he may not be held responsible for the infringement. Then these works may be assigned also these works like ordinarily like audio visual or other works in the AR world, they are assigned. The attribution of ownership for IP created in a virtual world is complex. This is especially true due to the fact that all the code permitting the creation as well as the creation itself may belong to platform. Any work created by a user of the platform would therefore be inherently intertwined with the platform which enabled the creation of the work. So, assignment also takes place, and there are certain problems with respect to the assignment as well. Now, coming to the patents or issues pertaining to patents in the field of AR, well, filing patents of AR is no different than the filing of any other computer program. In India, software patents are not granted, or the category of software patent is not given a patent protection. Here computer related inventions are given a patent protection. So, filing a patent on a AR or AR software is like any other computer related invention, or maybe like any other computer related invention if it fulfills the requirement of CRIs. There are clear cut guidelines on a CRI which are required to be referred in this case. Well, so far as the subject matter is concerned, AR can include various items such as system maps, data, business methods, features, functions, processes, and they are adequate subject matter of protection under the Patents Act. In India, we have Patents Acts of 1970 under which it may be a patentable subject matter. This technology would be eligible for patent protection in India is a question which may hinge on the determination of patentability of software or computer program. So, as I said that CRI or computer related inventions are patentable in India. So, you refer to the computer related inventions or their guidelines. There was so therefore, prima facie patent applications for AR technology coupled with hardware features should qualify as patentable subject to meeting other required criteria like novelty, non-obviousness and utility. If now we come to the next category of intellectual property, that is trademarks. The use of AR in advertising and more developed customized usage may make brands be prone to trademark dilution. Sometimes trademarks are used AR technology is used in advertising the brands, and when it happens the trademark dilution may take place of someone else's brand or someone else's trademark. So, who shall be made responsible is the user of the AR or the creator of the AR. The association of visual created in the AR world with a pre-existing trademark has potential to cause blurring or tarnishment. So, these are some trademark infringements or trademark violations, blurring, tarnishment, even dilution. So, if the trademark is associated or visual trademark is associated in the AR world with the pre-existing trademark, then it amounts to blurring or tarnishment, and it also required to fulfill some blurring or tarnishment requirements in that case. So, as per the Trademark Act, the test is to see whether a trademark has been infringed or whether there is a likelihood of confusion for a customer with average intelligence, etc. So, trademark law should give the owners of trademark the right to explain their trademark, but carefully, not whimsically, right. When it comes to jurisdictional issues, because in the AR, as I told you that it is a global or it has a global impact like any other exponential technology, it is not confined to the territorial bounds, it is really global, and depending on the application, any player from anywhere in the globe can connect to these augmented or virtual world and engage in a variety of activities, some of which may be legal or illegal depending on the user's jurisdiction. So, at some jurisdictions some say some plays are allowed and some are not allowed. In India, for example, a lot of gaming applications were banned. So, if that gaming application, if it is based on AR or VR, is yet played in India through some proxy servers, etc., or some VPNs, then it is problematic. AR realities include being subject to such dynamic jurisdictions. In this case, the US Federal District Court ruled. In this case, the US court ruled that the district court had personal jurisdiction over a non-resident operator of a massively multiplayer online role-playing game, in which the avatar of the user could engage in virtual business transactions with others and on property, it was held that the court had the jurisdiction to try the suit. So, US court held a non-resident of a US held him coming under its jurisdiction, because that non-resident of the US was the operator of massively multiplayer online role playing game, where he was doing some business transactions. The court unfortunately did not have the opportunity to rule on the substantive aspects of the suit, as it was settled out of the court later. Then crime in the AR world, as I was giving you the instance of women being groped. A woman named Jordan Belmare was virtually groped. Belmare recounted playing a multiplayer zombie shooter game when another player, who recognized Belmare as a female by her voice, began to make gestures that seemed like virtual groping. And Belmare reports that users' behavior, though utterly lacking in physical contact, seemed so realistic as to be disturbing. Under current law, virtual groping probably won't be a crime. Should the law be changed? Yes, definitely. Virtual groping might seem less serious than real groping, because there is no real physical contact, but the person perceived as if it has taken place in a real sense. Nonetheless, Belmare is doubtless that because of the visceral feeling created by virtual reality, such virtual groping will be highly upsetting for so many people, and the more visceral VR becomes or AR becomes, the more it feels to the victim like a real assault. So, indecent exposure, extortion, threats are also possible in the AR and VR world. Our current laws are not equipped to deal with these offences. Our criminal or other laws are not really equipped to deal with the offences. The Indian in the Indian context, the Indian Penal Code has brought a concept of digital rape, etc., but I doubt whether this kind of a virtual groping shall amount to outraging the modesty, or will tantamount to indecent behavior under the current set of laws. So, for that we need to relook at our current scenario or our current laws. It has some ethical issues and considerations also, like AR is already being used to advise, inform, manipulate, entertain, etc. Some of ethical concerns of AR include how end users will be affected, manipulated, persuaded. Further, there are ethical concerns about how information about the end user is being collected and used, and due to immersive and persuasive nature, the actual physical safety of end users and those around them become an ethical concern here. Some of the potential ethical concerns which arise with the application of AR are privacy, video game addiction, health, mental health issues, anxiety, etc. Persuasive computing, use of technology with a specific intent of influencing or modifying behaviors like brainwashing and making them terrorists. Safety for people who use AR applications and for those around them. Then the list is endless. There are no agreed upon set of ethical guidelines and standards for checking or for keeping the check on AR applications, which may result into some ethical concerns or ethical issues. There is no specific judgment on AR, but there are judgments on privacy and intellectual property disputes, which we discussed previously in the previous slides, which may be helpful here to fasten the liability, etc. in the cases of accidents. In the cases of intellectual properties, those judgments shall be handy to determine the ownership, authorship issues, etc. So, to conclude this lecture, I will say that AR offers exciting vision, or it offers lot of opportunities, but as more consumers utilize it daily or in daily lives, the governments and businesses explore the ways in which AR can improve operations. Individuals increasingly experience the world through the hybrid realities, etc. The transition will challenge existing parameters of privacy and public space, and it may also challenge the ethical concerns. To navigate this transition effectively, policymakers are urged to proactively address immediate risks while allowing room for AR innovation and its compliance to tackle emergency issues. And we need to adapt to these existing technologies and best practices. We need to establish a flexible framework defining the boundaries of privacy and public space. in response to these evolving or exponential technologies. So, with this note, I conclude, and I take your leave with the conclusion, or with the recapitulation once again, that these technologies has immense benefits, and they are offering immense business opportunities, etc. But yet at the same time they are challenging our legal contours or legal norms, and at this juncture, our legal framework is really not adequate or not robust to address the concerns which these technologies are challenging, which I am covering in this series called Law, Science and Technology at IIT Kharagpur. Well, my dear viewers, in this series we have many more exciting lectures to come, like virtual reality and law, and then 3D printing and law, robotics and law, then AI and law, and theoretical underpinnings of intersection of law, science and technology, etc. So, I urge you to kindly refer to all the lectures to stand benefited and to enjoy, and I am happy to receive your feedback and response on my email ID. Thank you very much, dear viewers, for patient listening and hearing. I am looking forward to give you more insights on these crucial aspects or crucial developments in the field of science and tech, and specifically the legalities of these crucial aspects of science and tech. Thank you very much, dear friends.